as one login, because there's still a couple companies that have like multiple participants. They might only be sharing a login. Okay, let's make a start.
Yeah.
Hi everyone. I'm William Chan, the Hong Kong tax partner, and recently the Indonesia changed the law. They passed the Omnibus Law, which has like a series of changes in the legal system and the tax law, which make it easier for companies to invest in Indonesia. And basically, they deal with the changes in labor law and the land law, and also, of course, this tax law, and what you get certain incentives in investing in Indonesia. And also, that's recently there's an article in the FT and a few other paper published as well. Indonesia have been in the hotspot. They are receiving a lot of investment from China and from Hong Kong, replacing India as like current hotspot in the South Asian country that are attracting a lot of foreign investment. So this is time that the Indonesian government changed the law as well. So this is time for you guys to know about the new law that could affect your investment in Indonesia. If you have not made one already, or you're thinking about making one, there's a good time to learn about it and get the best benefits of your investment in Indonesia. And today we have like two partners in our Indonesia office talking about this new omnibus law. One is like Kurniawan. He has a lot of experience. It's over 20 years experience in helping business to set up in Indonesia and restructuring, M&A work, and due diligence. And the other one is Hermanto. Hermanto has over 30 years experience, and he actually worked in one of the larger mining company in Indonesia before as well. And he's actually an experienced professional in a lot of tax advisory work, restructuring, dispute, and due diligence. He also is a tax attorney, so he can actually approach the Indonesian tax officer to sort out your tax dispute with the Indonesia officer. So without further ado, I'll leave Kurniawan to talk about the legal aspect of the omnibus law. Thank you.
Thank you, William, for the introduction. Good afternoon, everyone. My name is Kurniawan from Thornton, Indonesia, from the legal department. So we will start this today's discussion from the legal cluster first. So in this opportunity, we'd like to highlight some part of the what we call omnibus law, which relates to the new policies relating to the deregulation, how Indonesian government is now pushing forward e-government system for many things. We also now form a sovereign wealth fund, which will play a significant role in the upcoming years for the Indonesian strategic developments. We also highlight some points from the changes to our manpower law. So this omnibus law, as we believe that you have heard also about this, how this law has driven so much attention in Indonesia because of the coverage. This law basically amend around 79 laws and consists of more than 1,000 pages. There are ambitious purposes, objectives of this law. Of course, as the title suggests, the law is aimed to create more jobs for Indonesians. How jobs are created, then one of the important ingredients is, of course, to create the fair and proper rewards and treatments on the Indonesian employee side. But in general, we need to improve our investment ecosystem and accelerate all the national strategic projects. So this is basically the law, the background of the issuance of the law. And it is very ambitious because implementing regulations are aimed to be issued within 3 months. So it would be interesting for us to see later on. In this opportunity, we'd like to focus on the last 3 chapters actually from the law, because these chapters basically highlight two chapters basically highlight about the administration of procedures, especially those that are traditionally within the authorities of regional governments, how they are now coordinated under the central government control. So as we mentioned here, we'll go quickly through the slides. We mentioned here the relevant articles from this law, where it says, for example, in Article 1, number 19A, it's mentioned about standards of fulfillment of requirements as admitted by the central government. So one of the key changes from this law is that the central government will be the one creating the standards that will apply throughout Indonesia. Boundaries for exercising discretionary powers are basically more regulated now. So we can hope that in the future, regional governments will not abuse their discretionary powers, because exercise of this power must be within legal corridor, good governance principle, no conflict of interest, objectivity, and of course, good faith. And one important aspect from this deregulation policy is the introduction, actually not introduction, but I think it is more proper to say that this is a strengthening position of the central government of Indonesia to run an electronic system for the licensing arrangements. Because one of the important bases here, it mentioned that electronically produced decision from electronic system approved by the central government will replace printed decision with wet signature. In the Article 39, we mentioned about 4 types of deliverables basically relating to the licensing procedures and systems, which are license, standards, dispensation, and concession. So when we talk about license, of course, it is something that will be individually given to applicant. We talk about standards, which means that whenever there are standardized activities, the government will try to create standards for all those activities. Dispensation is the sort of permit given to applicant where, in general, activities are excluded or subject to prohibition or orders, while concession involve the giving of license where applicant will create a sort of cooperation with the authorities. One important aspect from this deregulation policy is that approval or rejection to be given to applicant within 10 working days. So it is very important now we have this limitation of time process in Indonesia. The other articles also impress upon the authority of our central government in basically monitoring and supervise. And this can be assisted by certified experts. So what we highlight from the changes introduced by this law is that how this law cleverly get around the traditional division of powers between central and regional governments. Because we can say now under this law, although this law stress upon the authority of central government, it is not necessarily mean that the central government basically eliminate the powers of the regions, but the regions has still the power to either approve or reject an application. But the central government basically say that you need to do that within an electronic system run by the central government. You need to do that within a constrained time process, which is by the latest of 5 working days after submission of complete application. So unless certain laws later on are issued with different time frame, you can expect in the future, whenever you arrange for licenses, you will get answer, because the system will automatically issue approval upon the expiry of the time limitation. It mentioned here, for example, in Article 176, how the central government will stipulate norms, standards, procedures, and criteria. So we can expect a unified, standardized norms, procedures, and criteria applicable throughout Indonesia. The law also stress upon how the regional government must be in line with these policies from the central government. It even mentioned that whenever a region is deemed to breach this central government's policy, the officials may not receive 3 months salary. And whenever this relate to a policy issued by regional government relating to regional taxes and levies, the respective region may be penalized not to receive funding from the central government. So it is very good how we see this law try to basically close any gap relating to these compliant matters between region and central government. It talks also about how the regions can receive funding from elsewhere, but will be under coordination with the Minister of Finance. It also mentioned how the regions must still provide any services through one-door integrated services electronically by use of system managed by the central government. So again, there's an emphasis here about the centralized system. License holders, when they receive approval, they will be bound to it, bound to the terms and conditions. And whenever there is any environmental damages, this law explicitly mention how the license holder must restore any kind of that damages. Now, one important article also introduced by this law relating to the land concession granting policy, how the government now really result-oriented policy relating to this granting of land concession, because in Article 180, it says that any land rights, permits, and concession not utilized within 2 years shall be revoked and returned to the state, and the relevant area will be transferred to become assets of the land bank. So we will have the land bank as well. Of course, this will be further regulated by government regulation, so we are yet to see how this goes. One other important aspect from this law is the formation of a sovereign wealth fund. So it is very interesting to see how now our government try to basically empower an institution with very strong legal basis, because the organs of this institution will basically be independent from the central government, aside from the two officials that will hold office ex officio as the head, which is the Minister of Finance and the Minister of State-owned companies. Aside from that, all other members will be professionally selected by a selection committee accountable to the president. And it is mentioned here in the law that basically this institution cannot be bankrupted unless proven insolvency status. Whenever there are any need for assets transfer, the Minister of Finance basically can instruct state-owned companies, other state-owned institutions to transfer some of the assets into this company, into this institution, which will be treated just like a company, and all those wealth will be considered as the wealth of this institution, can further be transferred to any of its subsidiaries, which can be formed by itself or with cooperation with private sectors. So it is very interesting to see later on. These organs, there are two types of organs, supervisory board and directors board. So Minister of Finance will act as the chief and Minister of State-owned enterprise as one of the members. 3 professionals appointed by the presidents for the supervisory board. Now, what is new also introduced by this law, and we haven't actually have any provisions in the Indonesian company law as well, is the introduction of a staggered board system. So it is very clear that the government will want to see stability relating to this institution, how the members basically will serve the same 5 years, but starting period is different. So for the initial period, 3 members will be appointed for 3 years, 4 years, and 5 years. And then afterwards, they will be appointed for another 5 years. Government regulation will be issued further relating to this institution, and they may create their own counselors board, they may create committees. Tax treatment towards this institution will be further regulated also by government regulation, and both central and regional governments are responsible for the provision of land areas and licenses for any national strategic projects. Okay, so that's about the State Wealth Fund. We also want to highlight some points relating to the manpower law. This is perhaps the most controversial points from the Omnibus Law, although it turns out that in the final form of this law, the proposed amendments are not actually that controversial. So, for example, for the use of expatriates, it will be further regulated, but still the permit from the central government. A good news for the investor is, of course, no manpower utilization plan is now required for directors and commissioners having share ownership in the company. Potentially a wider exclusion for the need of employment of Indonesian employee to receive transfer of knowledge. So if you know that whenever an Indonesian company employ an expatriate, they will need to appoint an Indonesian employee that will accompany this expatriate for the transfer of knowledge. So there will be wider exclusion, it seems, although skill development fund requirement is still there. About employment itself, nothing much changed actually by the law. Still, we have permanent and temporary workers. Temporary workers may be employed for more than 3 years now, as long as it meets the criteria to be further regulated. Remember that the language of the contract, even though there is no literal statement, Indonesian language should be used. Probationary period only apply to employees not with the definite time contract. But one important point from this law is actually the introduction of compensation for contract workers at the end of contract. It is not yet clear. It relates to employment period, but we will further hear it from the government regulation to be issued. About the outsourcing, there's a firmer statement now in this law where the outsourced employees are legally employed by service provider. One important point also how this law now mentioned that the employee's existing rights to be considered if moved to another outsourcing service provider. So we think, looking at the provisions of this law, this is aimed to protect the outsourced employees where the outsourcing service provider try to create another entity and move their employees from one entity to another entity. Now the law says that in case like that, as long as the basis for the work it remains the same, then any existing rights need to be considered transferred as well. Working hours, more flexibility relating to the overtime, even though not much. Break and leaves. Now, in the previous law, there's a provision about 2 months long break, even though in reality, only few companies actually apply this policy. So the impact from the practical point of view is basically not that much, because under the ministerial regulation number 51, it only mentioned that only companies that have applied this policy are required to maintain it. Wages policy is still the same, where the government up to the provincial level will set the minimum wage. Employees with same rank and similar responsibilities are entitled to receive same salary. No delayed implementation of minimum wage. So we are yet to see whether this means that whenever our government set a minimum wage, it must be implemented by companies without any room for delay. Same component about the salary. So 75% must constitute basic salary. Termination procedures are also basically the same. We still have a same package for severance package, but now the 15% deemed housing and medical care allowances is deleted. So it's a good news for investors as well. And also basically, one important thing relating to this law is that the previous law mentioned about the multiplication factor, how in certain conditions companies need to pay twice severance package element. Now it's gone. So I'll try to sum up what we have just explained. You can expect an electronic system, a stronger electronic system run by the central government in the 2021. there's a pressure on land utilization by the central government. So land reform program will definitely continue. You can expect more active role of government in various economic ventures under this sovereign wealth fund. Plus, the significance of changes to manpower law contained in the implementing regulations is yet to be seen. Okay, so that's from me, from the legal cluster. We'll hand it over to Pak Hermanto for the tax cluster. Thank you.
Okay, thank you, Pak Kurniawan. Let me request the screen first. Okay. Hi, everyone. Good afternoon. Thank you for attending this webinar. How are you? I hope everyone is good and keeping healthy and safe. So I will just continue with the Omnibus Law taxation cluster. I will cover in more detail the two first slide on the background and objective and summary of the key changes. And then I will just go very quickly on the detail, the tax changes in the Omnibus Law itself. And then I will conclude with the impact to business as a key takeaway of this webinar. And then we will continue later with the Q&A where we can answer any question you may have. Let me first continue with the background and objective of this Omnibus Law. Sorry. Okay, basically, in the beginning of the year, there are two draft Omnibus Law or bills on taxation and job creation. And during the year, because of the COVID crisis, there has been what's called emergency law, what we call it government regulation in lieu of law issued by the government, or in Bahasa, we abbreviated into Perpu number 1, 2020, issued by the government in 31st of March, which is later enacted as a law number 2 in May 2020. So Perpu is actually emergency law intended for COVID-19 crisis-related financial economic relief and measures. But it includes, however, two things in the draft Omnibus Law that become enacted earlier, which is the corporate tax rate reduction and for taxation for foreign e-commerce players. And then later on, when the discussion on the draft Omnibus Law bill is going on in the Parliament, on the, I think 5th of October, the Parliament approved the Omnibus Law and also include the taxation cluster, which is part of the draft Omnibus Law on taxation. So it was the Omnibus Law was signed. It's called the Omnibus Law on Job Creation, was signed by the President on 2nd of November 2020, become law number 11 and become effective on that day. So as Pak Kurniawan mentioned earlier, the Omnibus Law on Job Creation changes 79 laws. It includes taxation cluster as part of it in Article 111 to 114, which contain changes in various articles of the 4 tax law in Indonesia, which is income tax law, VAT law, general tax procedure law or KUP law, and regional tax law. In this discussion, we'll just cover the 3 main tax law: income tax, VAT, and KUP law. The objective of the law itself, as the name suggests, it's economic growth and job creation, basically on job creation. But the tax changes inside the taxation cluster of the Omnibus Law is aiming to promoting investment, improving legal certainty, encouraging voluntary compliance of taxpayer, and improving fairness between foreign and domestic business players. As basically that those are addressing what has been complained or what has been promoted by the government, like promoting investment, is basically to give more funding to or financing to the economy and to the business in Indonesia. Improving legal certainty is always complained in the past, like a lot of gray area in the regulation. So they try to tackle or handle the issue and change some of the rules. Encouraging voluntary compliance, so the government still consider still a lack of compliance in Indonesia, so they want to invite more taxpayers to be more compliant by giving some other different policy. And of course, as due to digital economy, there is borderless economy now, and where foreign business player can just do the business directly through digital media in Indonesia without having presence. Let me just continue with the summary of the key changes. As I mentioned earlier, basically the changes in the Omnibus Law taxation cluster change several articles of the income tax law, which is I put in blue. In Article 111 of the Omnibus Law, there are changes to the income tax law, which intended to promote investment, improve legal certainty, encourage compliance, and improving fairness. And then there is in the green color changes to the VAT law, and on the red color changes to the general tax procedure law. Most of these changes are basically welcome, very welcome changes, and provide some relief and encouraging to the business. Basically, if just going through one by one on the corporate tax changes, as I mentioned earlier, some content of the draft Omnibus Law already regulated in the Perpu. One of them is a reduction in corporate income tax rate, which is effective from 2020. And then they also regulate now tax exemption on dividend, intercompany dividend. So there is no more limitation or requirement for intercompany dividend, all exempt, except for dividend distributed to individual Indonesian shareholders, where there has to be a requirement for to be reinvested so that you can get the exemption. And also they also now provide to bring more funding to the country. The new law also provides exemption on reinvested foreign dividend. So if Indonesian invest overseas, they can bring dividend tax-free to the country as long as they are reinvesting into some business in Indonesia. The law also provides changes to or lower rate of withholding tax on loan interest from foreign loan. Those are changes where further regulation will be issued to implement that changes. The other change on the income tax law is changes on the definition of tax residency. So now the law provides more clearer definition for both expatriate and Indonesian national or citizen, where they can be Indonesian tax resident or non-Indonesian tax resident based on the time spent in Indonesia, like they stay in the country within the threshold of 183 days. So for expatriate, when they are considered as tax resident, as long as they meet certain requirements, they could be subject to sort of limited territorial taxation system. But and also for Indonesian, they could be foreign tax subject if they are meeting certain criteria. The last thing on the income tax, which is still subject to further regulation, the law which is regulated under the Perpu provides the income tax treatment for foreign e-commerce business. whether foreign e-commerce business may be subject to income tax or digital tax based on significant economic present concept in the future. So the law already there, but the implementing regulation in whether how to tax it, whether the government will impose tax or not, is still not yet regulated. So we are waiting for the implementing regulation. In terms of the VAT changes, the VAT changes include non-fatable subject on transfer of asset as a capital contributions. That is useful if a company is doing restructuring or doing capital contribution in the form of goods or taxable goods. And then there are some other changes related to non-delivery, non-taxable delivery definition for consigned good. In the past, consignment good on consignment is taxable delivery, and in the under the new law, it's no longer taxable delivery. And then categorization of coal has been also changed back into fatable good. Coal used to be in long time ago fatable goods, and then changed to non-fatable, and now come back again to fatable goods now. So over the period, about 20 years has been changed 3 times. And the other changes which has been waited for by entrepreneur, mostly on the relaxations of the right to claim input VAT credit. In the past, there are a lot of limitation in claiming VAT input if there are some situations where you cannot claim input VAT, but now they give more relief. Lastly, on similar to the income tax on e-commerce, VAT treatment for e-commerce player already also regulated under the Perpu. But this has been actually implemented because unlike the income tax, where for foreign company, they may have a tax treaty protection, but the VAT is imposed on domestic consumption. So the government already issued a policy whereby foreign e-commerce player now is required to be registered as a VAT collector if they meet the certain threshold. And other changes in the VAT is related to kind of a detailed information to be included in the VAT invoice, whereby they give more relief to certain buyer who may not have tax ID number. They can use their ID card number as the information to be included. The last change on the red is on the general tax procedure law. That is more like confirming on limitation and coverage of issuance of tax penalty notice. So they put a statute of limitation 5 years, similar to an assessment letter. The other changes, which is quite important to encourage voluntary compliance, is the law reduced significantly on interest sanction or compensation, and they introduce a new what's called Minister of Finance interest rate. In the past, most penalty is subject to 2% penalty per month, but under the new law, they use what's called new Minister of Finance interest rate, which is benchmark to the prevailing interest rate. So I can just go through quickly the slide for all of these changes. So this basically gives some just overview of the changes on the income tax, VAT, and the general tax procedure law, which is included in the Omnibus Law. Let me just go through quickly some of the important changes as tax exemption on dividend. I'll just go through quickly on the changes from the old law to the current law to the Omnibus Law, which is effective from 2nd of November. In the past, corporate intercompany dividend between Indonesian corporate entities, it has to be more than 25% shareholding to be exempt, but now no such limitation. Basically, dividend among between intercompany in Indonesia is no longer subject to tax. For individual shareholder, dividend still subject to 10% final tax, similar to the old law, but if the dividend is reinvested in Indonesia for a certain period of time, it can be exempt now. Also now apply for foreign source dividend. In the past, Indonesian company, Indonesian individual receiving dividend, they have to pay, have to recognize that income, dividend as income and subject to tax. And if there is any foreign tax paid, then they can claim credit. Now, if they reinvest that dividend in Indonesia for a certain period of time, which is at least they put a threshold of 30% of the profit after tax of the foreign subsidiary, then that dividend income will be exempt from Indonesian tax. I think that is just a limitation on 30%. If less than 30%, then the remaining will be subject to tax. I'll continue going with the residency status. This is quite important or changes, whereby the definition is more like gives some more clearance in terms of defining Indonesian expatriate. So under the Omnibus Law, it is specifically mentioned Indonesian or expatriate who is present more than 183 days in Indonesia will be subject, will be considered resident tax subject. On the other hand, on the opposite, then they are, if less than 130 days, 183 days, they will not be considered as resident tax subject. The difference is the income tax basis. Like for expatriate, if they are considered as resident tax subject, if they meet certain requirement now, like they meet having certain expertise and applicable for first 4 years since becoming resident, they can be taxed on limited territorial basis, like only Indonesian source income will be taxed. In the past, when they are considered resident, then they will be subject to worldwide income tax basis. On for Indonesians, they now can be confirmed subject to become non-resident tax subject in Indonesia if they meet certain requirement. In the past, there is an assumption like an Indonesian citizen will be subject to basically worldwide income tax basis. But now, if they meet certain requirement, they can be considered as non-resident tax subjects, and their overseas income will not be subject in Indonesia. So I will continue quickly on VAT law changes. This is mostly provide some relief where in the past there are situations where VAT input cannot be claimed as credit. For example, input VAT not reported in the VAT return and found during tax audit, input VAT charged from an assessment letter subject to after a tax audit they find something on input VAT you have to pay, no, cannot be credited. Input VAT which was obtained before the company is registered or producing vegetable good and service, in the past limited only for capital good can be credited, but now all can be credited, and of course subject to whether they can produce after 3 years or not. And then input VAT paid obtained prior to the registration as vegetable company in the past cannot be credited, now can be credited. The other changes of the VAT law, as I mentioned earlier, capital contribution in the form of asset is not subject to VAT, provided both parties are vegetable company. Coal again become non-vegetable. Good on consignment is not vegetable delivery. And this is more to identity of the buyer, as mentioned, and also retailer vegetable entrepreneur. This is regulated in the past, but not in the law, and only in the Minister of Finance regulation. Go on with the general tax procedure. The main important changes there is basically introduction of Minister of Finance interest rate. So there are some situations where based on depending on degree of non-compliance, now we can see the interest penalty is progressive. Basically, in the past it's just flat 2% per month, but now there is a sort of uplift, additional surcharge on the interest charges. At the moment, the Minister of Finance already issued interest rate for November and December, 0.57 and 0.53. So if there is an assessment issued in December, for example, then it is no longer subject to 2% interest per month, but now only 0.53 plus for assessment, plus 15%, so 1.78%. For the assessment, but for late payment, 2% per month now become only 0.53%. I think that is the main changes of the Omnibus Law. There is also some changes which has already effective earlier on corporate tax reductions. I think I just go through quickly now, not discussing this in this. And also e-commerce taxation, which has been effective much earlier on the VAT treatment, and also the income tax treatment, which is still subject to a lot of implementing regulations at this stage. And then I'll just conclude with the implications of these changes to the business. Number one, of course, the dividend exemption rule, no VAT on capital good on capital contribution, lower corporate income tax rate, provide opportunity for investment restructuring or business restructuring in Indonesia. And number two, on limited territorial taxation, this can be beneficial for expatriates who meet certain skill and work for a certain period in Indonesia. So for 4 years will be taxed only on Indonesian source income. For Indonesian migrant worker or high net worth individual who can afford to reside overseas, they probably can shelter their asset and income overseas, not subject to Indonesian tax under this new law. Appointment of VAT collector for foreign e-commerce player. At the moment, it is an official assessment by the Director General of the Tax. But of course, the DGT has the threshold where, for example, a year you have a turnover in Indonesia more than 600 million rupiah or $40,000 US, then you are basically expected to notify. There is a procedure to notify the DGT or the tax Minister of Finance, and then the Minister of Finance or Director General of Tax will appoint the company. Otherwise, then you may just wait until they appoint. But of course, there is the old law. There is still a mechanism for VAT collection, which is under the self-assessment basis. Coal mining company can now claim input VAT on their payment for our contractors, core mining contractors and supplies. So, but this may only be relevant to IUT license, which is subject to general tax law, and also Generation 2 contract of work, because the Generation 3 contract of work is still subject to the old law, so no effect. Omnibus Law is effective from 2nd of November, but provide no transitional provision in the law itself. So the government has already mentioned that they will issue implementing regulation in the form of government regulation and several Minister of Finance regulations to be issued very soon. So a lot of those changes in the tax law, in the Omnibus Law, is mainly beneficial because it contains more relief and relaxations to taxpayers. But of course, because of the revenue pressure by the tax authority, taxpayer need to anticipate more aggressive and detailed scrutiny. So I guess my last conclusion comment is the taxpayers to be prepared. So I think that's end my presentation. I hope it will be useful. I'll now pass it on to William for the next sessions. Passing on to you, William, now.
Okay, can everybody hear me? Yep. Yeah, okay. I mean, using Hong Kong as a holding company to invest in Indonesia, it's a fairly popular structure that a lot of people use. Hong Kong, why Hong Kong? Because it's like easier set up. We have like limited liability companies, which is standard, and there's no minimum capital requirement, and there's no local directors or shareholders requirement. So you can have like all your directors and shareholders to be your overseas head office directors and shareholders. There's no need for any local person to be in your company as a director or shareholder. Of course, you might want to have some local staff, but that's a different matter. And Hong Kong being a financial center, we don't have foreign exchange control, and dividend income is not taxable in Hong Kong. So all your dividend received from Indonesia is free of tax in Hong Kong, but of course you'll be subject to withholding tax in Indonesia. I'll talk about that later. Also, there's no withholding tax on dividend payment to your overseas shareholders. So you can literally have like tax-free except the withholding tax suffer. Under the double tax agreement with Indonesia, the dividend is 5% if you own more than 25% of the shareholding in Indonesia company. Otherwise, it's 10%. Interest is 10%. Royalty is 5%. Like I say this because we don't have tax on dividend in Hong Kong. So literally, you can have like the only tax leakage is the 5% withholding tax in Indonesia, because let's say you get $100 dividend from Indonesia, you end up paying $5 in withholding tax in Indonesia and getting $95 in Hong Kong, and then you can pay the $95 to your shareholders, and the shareholder no need to pay tax in Hong Kong, and the shareholder only actually getting to 95% $95 in their hand. The only changes in the double tax agreement is how you get tax credit in Hong Kong. That's the latest changes with the IRD. Although the IRD say that it's like they never changed the practice, but they have in the sense that if now, of course, dividends not taxable, but if you talk about interest and royalties, if you suffer tax in an overseas jurisdiction, and if that jurisdiction has tax treaty with Hong Kong, then you can credit the withholding tax suffered. But if there's no treaty with Hong Kong, then that amount cannot be credited and cannot be deducted at all. Whereas good old days, if you have like overseas income, we can always treat the exemption, or if it's taxable, then we can always get the credit. But like it's no longer the case. If with a no tax treaty, you can't get the credit and you can't get the deduction as well. So it will be a bit strange. But I think the IRD is going to clarify the situation, because we have been complaining a lot about countries that we have no treaty, like USA. A lot of Hong Kong companies dealing with US, and we don't treat it, and we end up not be able to get the credit on this tax withholding tax suffered. Okay, the other one is like Hong Kong, you can raise finance in Hong Kong. Like I say, Hong Kong is a financial center, so you get easy to raise finance, either equity financing or debt financing. So still, if you raise, if you're raising debt financing in Hong Kong and lend it to the Indonesian company, you have to be careful, because you might be subject to tax in Hong Kong on the interest income, because it's like if you raise the finance and lend it directly to the Indonesian company, we will have to do the operation test and to fulfill whether you are taxable, the interest income will be taxable in Hong Kong. So if you use your own fund, use equity funding, and use the money to finance the Indonesian company, the interest will not be taxable in Hong Kong. So that's something you need to think about. How do you finance it? What structure you use to finance the Indonesian investment? I think there's a few questions here. I've seen there's a withholding tax on service from Indonesia. So again, you need to be careful about it. Like I say, if the service are provided in Indonesia, you probably can claim offshore in Hong Kong, but again, you will suffer withholding tax in the service fee from Indonesia. If you're taxable in Hong Kong, then of course you claim the tax credit in Hong Kong. And the other one is like offshore tax exemption. Okay, assuming that you also provide services and you also receive dividend income, in order to that goes hand in hand with the business subsidy or obtain a tax certificate. If you need to get the treaty benefit on the lower withholding tax, you need a tax residence certificate from the IRD to present to the Indonesian tax authorities to get the beneficial withholding tax. But if you're only an investment holding company with no other business, you will unlikely to get, well, definitely you will not get a tax residence certificate from the Hong Kong IRD because you just receive dividend income. You have no operation in Hong Kong at all. So this is what it is. I mean, this is what the IRD actually claiming that they will not issue tax residence certificate if you're only an investment holding company. So without that, you might not get the 5% withholding tax on the dividend income. You might be subject to 10% as a normal case. Also, if you provide, okay, what happens if I also provide service income? I charge some management fees, provide certain services, back office services to the Indonesian company. In that way, then you will have to claim that those service fees are actually taxable in Hong Kong. If you try to claim those as offshore source income, again, because you have no management in Hong Kong or no income, no service being provided in Hong Kong, or the income not taxable in Hong Kong, you will not be able to get a tax residence certificate. So you need to think about it, you have to put management charges from Hong Kong to Indonesia. So you receive some form of income in Hong Kong and taxable in Hong Kong, and then you qualify to apply for tax residence certificate, and then you might be able to show it to Indonesian authorities, say you would subject to the lower withholding tax on the dividend. And also, when you think about the impact of BEPS 2.0 in future, because you have the minimum tax regime under Pillar 2, under Pillar 2, and if you do in digital economy, you will be affected by Pillar 1, where your actually where a customer are, you then subject to tax, not where your company is actually incorporated, where you provide the services. I mean, that's a really complicated topic in BEPS 2.0 and Pillar 1 and Pillar 2. So if you only pay a minimum tax in Hong Kong, if you are an MNC using Hong Kong to invest in Indonesia and you're only paying minimum tax in Hong Kong, you have to think about it, whether you might end up paying a true-up tax in your ultimate parent company. So that's a few something to plan. If you're doing a bit digital economy, using Indonesia as a development of the software or back office support, and you have to sell it into Indonesia, you might get caught by the Pillar 1, where your market is, then where you make your money is where you end up paying tax on it. So again, this is a fairly complicated topic, and there's going to be a lot to think about on transfer pricing and BEPS in the next few years. That concludes my presentation for today. And if you guys have any questions, we're happy to answer here. So if you guys can put in the chat box or raise your hand. Oh, I see Q&A here. How do I answer live? Type answer live. Oh, the question is the implementation regulation, will we establish the obligation to pay 2 times severance pay and 15% housing and medical treatment compensation?
Okay, I think I'll answer this one, William.
Yep, go ahead.
Okay, so it is true that this omnibus law, in respect to many parts of the manpower law, will further be supported by implementing regulations. We have seen how this omnibus law basically delayed some points from the previous law, which are, as mentioned in this question, about the 2 times severance pay. So just to refresh, whenever we talk about termination package in Indonesia, there are actually 3 components. One is the severance pay. The second one is the long service pay. Plus the third component is the compensation. So usually this severance pay and long service pay, we have a table based on the years of service. Whilst the compensation actually constitute any unused annual leave that need to be compensated, any repatriation costs, plus 15% of whatever is entitled by an employee from the severance pay component and from the long service pay component. Now, the 15% is gone. And also, in the previous manpower law, it mentions certain conditions. For example, if you want to terminate an employee in Indonesia, not based on the employee's fault, then the first component, the severance pay, need to be doubled. So now it is gone as well. The question is, will the implementing regulations reinstate these obligations? There is always possibility, but we think it would be unlikely, because after all the efforts and the pains suffered by the government when they released this law, it would be an anticlimax to just reinstate that in the implementing regulations that will be issued within fully the power of the central government. But of course, we all just wait and see how this will be further regulated later. Okay.
Okay, thank you. We have another 2 questions here, and maybe Hermanto can answer it. One is about whether VAT registration is required for foreign e-commerce players. And also, what about digital tax? If we're going to implement digital tax in Indonesia on the e-commerce environment?
Okay, thank you for the questions. Probably I need the slide. I can go back to the slide because I thought we only have 20-minute presentation, so I don't go through. The answer is in my slide here. Actually, if I go back here on the e-commerce, just hang on, bear with me a second. Yeah, basically here, as the regulation on this e-commerce has been issued much earlier this year, on the VAT, because there is no need of consensus or pillar 1 or 2 that you mentioned or explained earlier, VAT is more like a domestic consumption tax. So the government considered that any transaction in Indonesia should be subject to VAT. So under the existing VAT law, if we look at the current VAT law itself, when there is a buying of digital product or service from Indonesian customer, there is actually under the law an obligation to self-assess VAT by the customer. But of course, because the nature of digital product is the small value and numbers, and it is very difficult for the government to monitor, they cannot sort of capture that. But the law basically provides the right for the government, and there is an obligation for the buyer of digital product and services. But under the changes of the Perpu or Law number 2 on e-commerce, there is a requirement now if a foreign e-commerce player selling digital product or service in Indonesia exceeding the threshold, they may have an obligation to be registered as VAT collector. So, for example, the threshold is if they have annual transaction in Indonesia more than 600 million rupiah or 50 million rupiah per month, or they have traffic or access by the user in Indonesia exceeding 12,000 users per year or 1,000 per month, then they are they meet the threshold. They can be appointed as VAT collectors to register, collect, and pay the VAT. Of course, at the moment, the government under the law is the registration is more an official registration by the tax authority. So at the moment, they monitor from the system this kind of transaction, and they started to register from the month of July. The Director General of Tax already found some of the foreign e-commerce players like Google, Netflix, Pew. They start to impose or officially register those foreign taxpayers as foreign e-commerce business players as VAT collectors. So when they are appointed, there is a formal appointment by the Director General of Tax. So they will get the letter of confirmation, and then starting the following month, they start to collect VAT. And if they are not complying with that rule, of course, they will be subject to penalty under the tax law. And even if they are still not complying, there will be a possibility that their access is blocked by the government. They cannot sell their product, digital product and service in Indonesia. So up to like every month, like usually early in the earlier days of the month, the government start to register from July. There are about 8 or 10. Then every month, August until November, July to November, there are already 46 foreign company registered as VAT collectors. So the government keep approaching all of these companies, but of course, under the procedures, there is also a mechanism for a taxpayer to notify if they want to be appointed as VAT collector. So the tax authority is anticipating and expect voluntary notifications by foreign e-commerce players selling digital product and services in Indonesia, because at the end, they would like to register all of them so that the VAT collection on consumption of digital product and services in Indonesia are complied with. If for mostly for B2B, where the transaction is made under the agreement, either certain agreement between company A in Indonesia and company B overseas, there is, if the foreign company is not registered, there is still an obligation for the Indonesian company under the VAT law to self-assess that VAT. So at least the government or the tax authority still can collect the VAT through the customer or user in Indonesia. With regards to the digital tax or income tax, the law also already regulate what they call it income tax or electronic transaction tax. In the past, there is no regulation on this in the income tax law, but likely under tax treaty, as you may be aware, it would be not subject to any tax in Indonesia for sales of digital product and service, because there is no physical presence or definition of permanent establishment, because company earning income from other country can only be subject to tax when they have a presence of permanent establishment. But under the new law as regulated in the Perpu number 1/2020, foreign company may be subject to tax on as a permanent establishment if they are meeting what so-called significant economic presence rules, which is basically under like consolidated gross turnover of the group up to certain amount, or sales in Indonesia up to certain amount, or active user in digital media in Indonesia up to certain amount. So we are still waiting for implementing regulation on this. So I think, as William mentioned, this is still waiting for consensus under the OECD on the Pillar 1 or Pillar 2, whether the government of Indonesia is also waiting for that, because they cannot self-impose or require or change the permanent establishment definition. Of course, Indonesia already changed the domestic rule on the PE, including the foreign company selling digital product and service meeting the SEP rule. But when you are looking at the tax treaty, likely then the current treaty provides protection for the PE. But this law also provides that alternative taxing by, if not taxed as a PE, then the government still able to tax the transaction under what's so-called electronic transaction tax, or ETT. So ETT is imposed on sales of digital product to buyer or user in Indonesia through the e-commerce player. So while if it is subject to income tax, then it is paid and reported by the foreign company directly on a PE basis. So we are waiting for the Minister of Finance to issue these implementing regulations. But we recently hear Minister of Finance already mentioned in the media that soon the government will issue a policy to impose what's so-called digital tax on digital product and service sold in Indonesia. I think that is from Indonesian perspective, it is considered as same level playing field, like a fair imposition of tax both for domestic and foreign business player. Because you could imagine it's like in Indonesia, the domestic business, when they want to sell digital product or digital services like similar like a Netflix or View, then they have to be registered as taxable company. They have to register as taxpayer. They pay corporate tax. They pay a lot of other taxes. But suddenly, for foreign taxpayer, if they are selling their product and service, they can freely sell Netflix and sell their product and service in Indonesia. If they are not subject to any income tax or digital tax, then it is not fair for the Indonesian business player. So I think that is just the idea on background why the government considers that they have to impose digital tax on those sales of digital product and service in Indonesia. But of course, the government will respect international agreement or treaty. Of course, they are waiting what would come up with the OECD discussion, which has been again delay. They have not issued decision. We would expect there will be something coming up on June next year, I guess. Right, William?
Yeah, they expect it to be in middle of next year to come out with the final paper. They issue the guidelines, the blueprint in October. There's like 200-something pages on Pillar 1 and another 200 pages on Pillar 2. And it is a boring reading of it. It's like, yeah, the tax going to be implemented one way or the other under Pillar 1, because they're going to come with a consensus among the big players, and then levy tax on the on where your market is going to be, and not where your good old me and Hermanto, the old man, the brick and mortar.
We can dispute it that.
Yeah, I'm older than you, Hermanto. Don't worry about it.
We can dispute that, right? Who has the right to tax that?
Yeah, right to tax, and then not where you think where your company is incorporated and where you have your management control. This is where you actually perform your services or sell your goods.
Right.
And then you end up paying tax. But let's wait and see. It's a formula to calculate under the Pillar 1. I've yet to see that whether that we come to consensus in middle of next year. But that's what OECD claimed they would do. That's what we have to wait and see. And I think for most of the Asian countries, I mean,
as consumer market,
we are consumer market, so we are the one that's already benefiting in a sense that unless you sell it to you have your digital product sell it to America, the other way around. But mostly us buying online, we have the biggest kind of like highest population, and we do more online transactions than most other places in Asia. In here, and besides Hong Kong, we have 8 million people, but Indonesia and in Vietnam and all the places, that's India as well. They have India have imposed digital tax, Australia in digital tax, France has digital tax.
Right.
So you can see that's happening everywhere. So this is like another hot topic for next year, definitely.
Yeah.
But this is going to be complicated stuff. Like Pillar 1, I've taken ages. I still not understand the Pillar 1 thing. I'm not going to read through the 200-something pages, but I just have a summary.
Well, I guess I've been hearing since last year the Director General of Tax here, like waiting for. I think they mentioned last year that there will be sort of an agreement or consensus in June 2020. But in fact, it's now delayed another year. So I guess the Minister of Finance in Indonesia see that it is unfair now, where foreign business player or e-commerce player can sell their product and digital product and service without paying any tax in Indonesia. So that's probably the background why they will soon. They already mentioned in the news media that they want to tax. That to give a fair level playing field to the Indonesian businessmen.
Yeah. Okay. Then we have one other question. It's about. I think this question is coming from. Looks like that someone's actually working in Indonesia, and then now they have moved back home because of COVID-19, and they were spending less than 183 days in Indonesia, which meant they were spending more than 183 days in the home country. So I think what happened to that tax situation in Indonesia? They still need to pay tax in Indonesia, or they have special rules on it, relaxation on it?
This is not an easy question to answer. Maybe I can ask you a question first. When they are returning to Hong Kong and then stay there for 183 days in Hong Kong, whether then they are tax resident in Hong Kong, whether they have to pay tax in Hong Kong or not, because they are earning salary from Indonesia, or maybe Hong Kong is not.
No, because if you are providing service in Hong Kong, if you spend more than 60 days in Hong Kong, I mean, other country in general, I'm talking about if you actually spending 183 days in a certain country, you will become a tax resident of that country because you will have so you might be subject to tax in your home country again.
Yeah, I mean, this is not easy to answer, right? Like, what is the Hong Kong rule for this expatriate when they work in Indonesia, but due to COVID, they have to return home, and then they work remote from Hong Kong. So they are working and they are earning salary from Indonesian company, but they are working in Hong Kong for more than 183 days. What would be the situation there?
Revenue, the IELTS is really strict on this. We have I in a meeting talked to them about this thing. They're really strict on it. If they actually work in Hong Kong and breach the threshold of being taxable in Hong Kong, they will tax you. So they don't care whether it's due to COVID-19. They don't have special exemptions.
that could be double taxation, right? Because in Indonesia, when they are still receiving salary and they still subject to withholding tax in Indonesia because the employer have to deduct withholding tax. But of course, there is a technical debate or argument that they can be considered as non-tax resident for this only 1 year period. But I think the same issue will also happen in the following year, where the tax office suddenly see there is inconsistent treatment for only that one particular year, that suddenly this expatriate tax resident subject, Indonesian resident tax subject, and then non-resident, and then another year or next year resident. That may attract the tax authority who may question that.
Indonesian tax authority have not issued any special relaxation because of COVID-19.
Well, we have not seen any specific question, but if we just interpret from the rule that I think in the Omnibus Law also mentioned on the definition of non-residency tax status, this may, well, I think there is some requirement to be considered as non-resident tax subject, which is subject to further implementing regulation. We will see whether I would expect there are a lot of questions already raised to the Indonesian tax authority, and we would expect there is a kind of exceptions only for COVID related relief. So we will see. I think we cannot answer straightforward on these questions, but there is a potential double taxation issues. Strictly from technical viewpoint, as you mentioned, if they return to Hong Kong, then because they spend more time, 183 days and more in Hong Kong, then they will be a Hong Kong tax resident, and it may not be Indonesian tax resident, whether or dual resident with tax credit. So that is still subject to question, I think. We have to ask the tax authority and wait until they actually can give some relief in Indonesia under that situation. So okay.
I mean, the year is coming up, and then I'm sure there's a lot of this question will come up because people are now stuck in a few places. I just have a call this morning that people get stuck in Australia, and we have problem with it being
okay.
tax now because two directors got stuck in Australia and not being able to get out.
Right.
And that's another story. Okay. I don't see any people have any other questions, so we will conclude the webinar today. Thanks for the speakers, and thanks for all the people who attended the webinar. And if you have any questions, just email us, and we will try to reply to you guys. Okay. Okay. Have a nice afternoon. Okay. Bye.
Thank you.
Bye.
Bye.
Thank you.
Bye-bye.
Bye-bye.